Can you help them get around?
All
Yeah, I have a little IT. You should get going, but
Okay.
don't be surprised. This guy's gonna here to deal with a little
Okay.
IT.
Thank you, Judge. Morning, ladies and gentlemen. Obviously, next door neighbors should be able to resolve their differences without having to bother judges and juries who have better things to do. So here we are. So why are we here and what do we need y'all to do about it? What brings us here today are the rules that allow property owners to use and enjoy their property in peace, quiet. And the first rule is this: don't go out of your way to annoy, harass, cause harm and inconvenience to your neighbors. That's called a nuisance. And the second rule is, for property, use it or lose it. And what that means is, if you don't use your property for long enough, we're talking years and years and years, decades, you can lose the right to that property. And it also means, and that applies to people that you bought your property from. If they didn't use it for a long enough period of time, what you bought from them is not what you thought you bought. So let me tell you the story of why we're here and what happened. Next. So Mr. Logan and I are trying to do this, and it's sort of like a quarterback putting in motion. Hit the next slide, down button. There you go. Next. Keep going. So next. John Noel and David and Stacy David moved in next door to the Andersons. We're talking about these two properties, keep going, at the corner of West Andrews and Haversham Road. And that's the David property here on the left and the Andrews property here that fronts on West Andrews. Next. So the timeline is that the Andersons bought their property in September of 2018 and the Davids bought their property in March of 2020. So the Andersons lived there for a few years before the Davids did. Next. When the Davids bought their property, before they moved in, they started doing construction on their property, which obviously they have every right to do. Did some painting, did some work on the interior. We don't know, they've obviously never had the Andersons over for dinner or cocktails. But the problem started immediately with the construction. Next. What happened is, keep going. What happened is the Davids workers who were working on their house, they didn't park on Haversham, they didn't park in the Davids driveway. They parked here on the frontage of West Andrews, in front of the Andersons' house. Next. And in order to get from West Andrews to the Davids' property, they walked all over the Andersons' property. Okay? So why'd they do that? Well, it turns out that the Andersons' property has a couple of easements on it. Next. The first is what we call easement 1, which is parking pad, and actually the Andersons owned the parking pad. The Davids have an easement to use the parking pad. And then there's also this easement down here, which we call easement number 2, which is the main issue of dispute in this case. So in theory, the workers had the right to use easement 2 next. But they didn't. They used virtually everything other than easement 2. Next. So going back to the timeline, what we see is in April of 1996, 24 years before the Davids bought their property, this lady named Martha Reeves Smith created these easements. Why? That's not for y'all to worry about. That's construction of an easement. The judge is going to tell you what the easement means. So you don't need to speculate as to why she did it or what she meant or what the purpose is. The judge is going to tell you all that. Next. So we started having encounters almost immediate. The first encounter was over these construction workers. The Andersons tried to reach out, sent an email Don't know if it was the right email, but they tried to complain about it, nothing happened. Next. And then there was an encounter over trash. The Andersons or someone from the Andersons' house had the audacity to put a piece of trash in the big construction roll-off dumpster in the David property. And they did this because these workers, when they're blocking West Andrews, they're blocking access to the Andersons' trash cans. In the city of Atlanta, when they come by and they see a truck blocking the trash can, they're gonna go on down the road. So the Andersons' trash wouldn't get picked up like it should have been. So they put some trash in the David dumpster. Mr. David came over, saw Mr. Anderson's cooking something on the grill, complained about it. Mr. Anderson explained why they did that. Oh, okay. And that was it. That issue went away. Next, the Andersons were doing some work on their garage. They had a detached house. They have the house here and the garage over here, detached garage. They were cleaning out the space above the garage. They were going to finish it and maybe make it into a bedroom or something like that, which they have every right to do, obviously. Mr. David disagreed. He came over, knocked on the door. Claire Anderson answered the door, and he told her, "You have no right to do that. People can't live above your garage." And she's like, "Okay, thank you very much," and closed the door. Next, we have disputes over fence and facade. Go to the next one. So, as a result of the construction workers going across the Andersons' property, they built this fence that divides their property. And we see sod here, and we see pine straw here, and we see these big, bold stakes and pink and yellow ribbons. This is the Andersons' property. This is easement area 2. These big, bold pink and yellow ribbons have been placed there during this litigation by Mr. David to make sure that the Andersons know, don't step on my property. But the problem is, and the reason we're here is because February 21st, 2021, the Andersons were doing some landscaping. They were having sod put on their property. This is their property, no easement whatsoever. None, no easement. And they're planning to do some landscaping here in the easement, but they never did. We'll get to that. So that morning, Mrs. David sees these workers, these landscapers, delivering sod, pallets of sod. And the sod is placed on the street and in the yard in front of the Andersons' property. She does not like it at all. She gets in her car, drives down her driveway, turns right on Haversham, turns right on West Andrews, drives down there, rolls down her window, and Mr. Anderson is working in his basement office. His basement office kind of faces the same way as this part of the garage. He's facing all of this. He can see what's going on, and he can hear the noise. He hears Mrs. David yelling at his workers, telling them, "That's my property. You can't put sod on my property. I'm going to call the police if you don't stop." And Tracy gets up and he's on his way to talk to her, and she storms off. He has to go to a meeting at the office. He comes back around lunchtime. He's up in his dining room. He sees Mrs. David driving in the driveway, because the driveway is about 10 feet from the Anderson property. So he's mad. He's also received a phone call from the landscaping boss. I'm not going to tell you what it said, but he was very mad as a result of that phone call. So he goes out to talk to Mrs. David about this. And he walks out there, take that down. And he says, he starts walking up to her like this. He wants to talk to her. She rolls down her window. He's on the same side. And he says, "You can't yell at my workers like that. Don't yell at my workers." Rather than saying, "I'm sorry, apologize," explaining. She says, you're a horrible man. You're a horrible man. You've had multiple wives, which is not true. Claire is Tracy's one and only wife, but she calls him a horrible man. You've had multiple wives, and he lost it. He lost his temper. He was mad when he got there, and she added fuel to the fire, and he lost it. He called her a fat bitch. And he regrets it. Well, number one, he's going to admit saying it. He's also going to explain to you he regrets it. He's apologized. Not his finest moment. All of that stuff. Does not matter. Next. So this is, on my timeline, this is in red. Because this is why we're here. Because of that. Next. 2 days later, Ms. Sturm sends a letter to the Andersons. Next. Next. It's a 3-page letter, and it's a very, clearly it's a cease and desist or else letter. She tells him, go back. The Davids have sole and exclusive use. Unfortunately, you continue to engage in conduct that intentionally and blatantly disregards and tramples upon the Davids' exclusive rights to use and enjoy the easement areas. Next. She says you have trespassed, engaged in unlawful clearing and cutting of trees without an arborist permit, which I think is a crime in the city of Atlanta, I'm not sure, and other vegetation. She says this. She says you've also installed illegal surveillance cameras on your property. He says down here, please be advised that such conduct is not only illegal, but constitutes criminal conduct. Is accusing him of multiple crimes in this letter. Next. She concludes by saying this, if you don't give me everything I have demanded, we are going to sue you. We're going to seek all damages. We're going to seek an injunction. And she finishes by saying this. Next. Including placement of any and all appropriate liens on your property. That's pretty serious letter from a lawyer. Now, bear in mind, all this other stuff we've heard about, the removal of the trees, the removal of the vegetation, the surveillance, they've been there for 11 months. We haven't heard one word about any of that. This is all raised for the first time 2 days later, 2 days after what I call the incident. Next. In response, Mr. Anderson, as a lawyer from Alston and Bird, a very, very big, very well-recognized firm here in Atlanta. Mark Rushi writes a letter, brushes back on everything. Tracy thinks it's resolved. Doesn't hear anything for the better part of the rest of the month. Next. Little did he know that the next thing that happens is Ms. Sturm's office prepares what is called a verified petition for stalking temporary protective order. Basically accusing Mr. Anderson of committing the crime of stalking. And Mrs. DeVee verifies this. She signs it. It's a verification. She takes an oath, just like the witnesses who testified in front of you are taking. She's swearing that everything in here is true and correct. Accusing Mr. Anderson of crimes. Next. But they don't file it for a few weeks. The next thing they do, and we didn't know this at the time, we have since learned it, on March 18th, 2021, Ms. Sturm has a discussion with a fellow named David Shostak. He is an arborist. And what they are talking about is building a claim for damages for the removal of vegetation and trees from the easement. Next. The petition. Keep going. Next, the TPO petition is filed on April 2nd, and these these things, I don't know if y'all know anything about it, but you can get a temporary protective order, 30-day order. It's ex parte, meaning it's just you and the judge. The other side doesn't know about it, doesn't have an opportunity to respond or be heard. So this is issued ex parte by a judge and is served on Mr. Anderson by the Fulton County Sheriff. That's when we get involved. So we have to defend the TPO petition, but we know beyond any shadow of a doubt that a lawsuit is going to be filed between these parties over this relationship. So we filed a lawsuit on April 12th of 2021 because we have a joke around my office. What do you call somebody who threatens a lawsuit? You call them a defendant because we want to go first and last. Now, so we filed this lawsuit against the DeVees for three things at the beginning. Number one, we wanted a declaratory judgment as to whether the DeVees were right that they have exclusive use to the easement, meaning if this is the easement line, Mr. Anderson steps across it, he can be arrested for criminal trespass, even though he owns the property and pays taxes on it. So we wanted to get the court to rule on that. And that's an issue of law for the court, just like these objections and other things Judge McBurney said. And I don't know exactly how he's going to phrase it, but I'm confident that at the end of this trial, he will tell you as a matter of law that the Andersons have the right to use their easement areas as long as they don't actually interfere with the Davis uses. Next, we wanted a jury to tell us whether the easements had been abandoned or extinguished, because Mr. Anderson will tell you when they moved in 2018, though that easement was a complete hodgepodge. It was a junkyard. There wasn't any beautiful landscaping. It was a dumping ground for yard waste. His prior owners had some railroad cross ties that they used as a walkway. Whenever those would rot, they'd pick them up and throw them into the easement. And also that easement area, which the DeVees will tell you is beautiful in nature. We loved walking on it. It was a snake pit. It was filled with copperheads. Mr. Anderson killed 14 copperheads, but now that's a trespass. So we also filed suit over the trespass by the workers. That's not really that big a deal. If none of this had happened, we wouldn't be here about that, I guarantee you. Next. Now, by this time, April, when we filed the lawsuit in April, it didn't appear that the Davids had actually done any uses of the property that we could tell. But starting in August of 2021, after the lawsuit's been pending for a few months, the Davids actually start using the easements. Next. Now, I've got three videos here I want to show you. They're just a few seconds each. This first video is the frontage of West Andrews, the easement area, the frontage area. So you can see that there's no path. There's no way for workers to carry their tool belts and heavy equipment to get back there to do construction. It's in the path that somebody uses for their morning runs. It's impassable. Hadn't been used in decades. You see here we have the ribbons showing up. So that's the entire frontage of the easement. That video is taken August 12th, 2021. Next video is literally a few hours later that very day. Here's Mr. DeVee. Decides to install some sports nets on this wet, mushy ground. He sees Mr. Anderson videoing him. He picks up his phone and calls somebody. Who does he call? We do not know. We asked him, he doesn't remember. We put his lawyer on notice to preserve his call log. Disappeared. Don't have it. Next video. No, it's all right. Black spot. There you go. A few hours later,
Here's the net thing they put up.
Mr. Anderson, there it.
They're over there cleaning out something. Don't know what, but they're tearing up my property.
Okay. Next slide. So the first time we actually see any uses is during the lawsuit, and all of this happens on August 12th. Over the weekend, this is a before picture, Friday, August 12th, after picture, August 15th. Next. They've cleared the easement and left a nice little thank you here for Mr. Anderson and the city of Atlanta. That's not the only way they've used the easement during this lawsuit. Next. Next. Mr. David has put the lawn chairs out there because he supposedly likes to use easement too for ingress and egress for his runs, and he likes to sit here afterwards and have his morning coffee after running. Put these big sports nets up in this mushy, worthless area.
So you're doing some closing argument here as well? If you want to give a preview to the jurors of what the evidence may show, you can hang adjectives on those potential facts in your closing.
I apologize for them.
It's okay.
The evidence will show that the Davids have installed these nets in the easement area. We'll also show that the Davids have a very nice, well-manicured lawn in their backyard, which some people might think would be a better area for this type of work. We've complained about these nets. They're still there this morning. Next. So after this, we amended the complaint and we added a claim for nuisance because of the intentional actions in putting these nets up there for what we contend is not a legitimate purpose. Next. Next slide. Now, the Davids filed some counterclaims against us. Mainly trespass. And the trespass, as I understand it, I stand to be corrected during the trial if necessary. But as I understand it, the trespass, or one of the trespass claims, relates to throwing trash in the dumpster. Next. Well, somebody in the David household was so upset about the trash in the dumpster that they actually took a picture of the trash in the dumpster. A couple of pictures, and I don't have it on this, but they zoomed in and you can see that this is actually addressed to Tracy Anderson. So we didn't hear anything about this before the lawsuit, but now it's a big issue. Next is, they say that Mr. Anderson has removed all sorts of vegetation from their yard. Remember, next slide, before the TPO petition was filed, next, Mr. was having these discussions with this arborist about their damages model. And the arborist prepares a report, next. And he's claiming down here $87,000 in damages to replace the landscaping that has been removed. And of the 87,000, 65,000 of it is to replace this one 10 by 15 bush, 10 by 15, one. He's going to replace it with 2,250 3-gallon plants, potted plants. Next. So it's the ratio for that is 2,250 to 1. That's in Mr. Showtack's report. We don't know if he's going to come in here and tell you, I made a mistake. It should have been 250 or 225. We'll just wait and see. But next. What we do know from his report is he calculated the area of what we're talking about. The area was approximately 1,800 square feet. So he's planning to put 2,250 3-gallon buckets of this stuff. And that doesn't count all the other stuff that he's calculated. 2,250 3-gallon buckets in an 1,800 square foot area. So we'll see. We'll see. Next. Now, we'll see if or how they can continue to use the easement for the sports nets and their walkways that they've cut in, if they put 2,250 of these buckets in here. Next. So when you look at the timeline of key events, the evidence will be, I believe, at the end of this trial, you'll agree, that none of the trash removal, none of the putting that FedEx box in the dumpster, that's not why we're here. Next. We're here for one reason only. Because Tracy Anderson, after being provoked, lost his temper and used a bad word. He's apologized to it or for it multiple times. He owns it. He's the CEO of a company with 265 employees. He'll tell you he referees fights all the time. Not proud of this, but that's why we're here. Mrs. David, I doubt if she will accept any responsibility for what happened here. Next. At the end of this trial, we're going to ask you for several things. First, we're going to ask you to extinguish easement 2 for two simple reasons. Number one, factually, it was extinguished because it was formed in 1996. It had not been used in the 24 intervening years. So it was gone. They had nothing to buy. Now you're going to hear, I anticipate, from the prior owner, Mr. or Mrs. Darby, maybe both of them, who may tell you, oh yeah, we loved it, we used it for its peace and beauty and this, that, and the other. But we will prove actual adverse use by using it as a dumping ground. And Nyker used to own the Anderson's property. She will testify by Zoom tomorrow. She will tell you that their landscaper used it as a dumping ground, and she never saw the Darbys use it. Now, Miss Darby, Mr. and Ms. Darby, they both tell you, oh, we loved it, we used it. They moved to Florida in 2001, became permanent full-time tax residents of the state of Florida, meaning you have to live there for at least half a year plus a day. So we think that's sufficient to prove abandonment and adverse possession. The other reason is this: we all know if they continue to have rights to this easement, you are not the only jury who's going to have to spend 2 or 3 days of your lives refereeing a fight between the Andersons. Next. Next, we want a jury verdict in our favor on the nuisance claim. And the measure of damages for that is the enlightened conscience of a jury. So whatever y'all think is fair. Next, for compensatory damages for that. And also, we have a claim for bad faith attorney's fees and for putting these nets up in the course of this litigation. We think we will prove that they did so with the specific intent of trying to escalate tensions between the parties as opposed to trying to de-escalate tensions between the parties. So we think that's bad faith in the underlying force of the conduct. And finally, you're going to have a box on your verdict form for punitive damages. It says if they've acted intentionally or with conscious indifference to the consequences of their actions, yes, and we can get punitive damages against them. And on their counterclaims, obviously, want to reject all counterclaims. Or on the off chance that you think putting that cardboard FedEx box and that chimney screen in this big old, whatever it is, 15-foot dumpster, actually did interfere with their use of that dumpster, give them $1. They don't care. But as for the interference, next. Because on the Bush's claim, the $65,000 to replace that one bush, you're going to see lots of pictures that the DeVeeds took of the Anderson property and the easement and all this stuff when they got mad. When they thought the Andersons were doing something they shouldn't do. You're gonna see lots of pictures of that. What you're not going to see is a picture of this beautiful 8x10 bush that used to be there and has been removed. Pure speculation, pure speculation. So you're gonna have to, we're gonna ask you to reject that. And the trash and dumpster, I've talked about that. So at the end of the trial, we're gonna ask for a verdict in our favor on all counts and ask for a verdict in our favor on all of their counterclaims. So before I sit down, let me say this. Go ahead next. You know, I'm a lawyer, and I know a lot of people don't like lawyers, but I'm proud to be a lawyer. I take an oath to do what I do. And our job here this week is to help you find the truth and do justice between these parties who can't figure it out for themselves. And y'all got a jury summons and you're here and it's a big inconvenience for you. Some of you have travel plans later in the week. I understand that. We certainly appreciate you being here. My job is not to make your job one bit harder than it needs to be or take one bit longer than it needs to be. And if I do, I want you to hold it against the Andersons because I'm their lawyer. I represent them and I speak for them. So if I do something wrong, hold it against, if I intentionally do something wrong, hold it against them. And my friends here on the other side, they're lawyers just like I am. They take the same oath that I take. They have the same duties and responsibilities to you that I have. And I'm sure they will agree with me that if they waste your time, if they make your job harder, if they try to make up a claim out of whole cloth, you should hold it against them.
Yeah, I hate to object to someone's opening statement, but this is a closing argument.
No, I think he's closing, so
I'm
we
done.
don't have to do any more closing in his opening.
I'm done, Your Honor, so
All right.
thank y'all.
We will pivot to counsel for the Davids. Yes,
Yeah.
sir.
Thank you, Judge. Good morning. I'm Casey Sturm. Along with my colleague Jeff Schneider, we represent Jean Noel and Stacy David. I do not disagree at all that all of us probably sitting here believe that neighbors should be able to work things out. That you should be able to knock on that door, on your neighbor's door, and say, "Hi, I'm your new neighbor." That's not what happened, and that's why we're here. Let's also be real clear, just like we tell our kids. We know there are always two sides to every story. And I'm going to talk to you about what really happened here. Okay? And that's on March 27th, 2020, my clients, they bought their dream home. Okay? We all can envision what that may be like. We're going to take that next step, right? We're about to open that new chapter in our life. We're full of hope. We're full of excitement, right? They've got two young teenage kids at the time, and they're ready, right? We're going to make this place our home. We are excited. At this time, they don't know the Andersons. They don't know their next door neighbors. They've never met them before. They're excited though. They could have never have fathomed what was about to take place. Okay. This is not your normal, oh my goodness, what have I walked into with my next door neighbor? Okay, you could never fathom what was about to happen. It started almost immediately after they moved in. And yes, they bought the house, they had plans to renovate it. They started renovation shortly after they moved in. What happened though is not the picture Mr. Anderson wants you to see. What happened is there was a pattern of abuse, of aggression, of willful disregard for their new neighbors. They haven't even said hello to. Their new neighbors who have just moved in. You heard Mr. Anderson, Mr. Edwards admit his client yelled at Mrs. David. He called her a fat bitch. He also said, "You're going to die." Mrs. David's husband travels internationally. He's gone almost every day of the week, Monday to Friday. You think about how those kind of comments would make you feel if you just moved into a house. Can hear me. They make me feel like that. How does that make you feel when you just move in? You are scared. What am I living next to? How do I handle this? Do I need somebody to protect me? So since shortly after they moved in, what we will show you is that there is a pattern of this aggression, of this abuse, of this harassment. Let's make no mistake about it. They're going to admit several things. They admitted they cleared easement too. They will admit that they attempted to fence it off completely so that the Davids could not access it. They yelled rude comments. I'll tell you more about that because Mr. Edwards said, "Oh, Mr. Anderson regretted it." You didn't hear him say, "Hey, he went back over to the neighbor's door and knocked on it and said, 'Hey, I'm real sorry about that. Can we start over?'" Didn't hear that, and you won't hear that. Didn't happen. This harassing continued from the day they purchased to today. It's ongoing. That's why we're here. So as you can see, this dream home has for them become a living nightmare. This is their day to day. What is this man gonna say? What is he going to do next? Let's talk about a few things. This case, it involves easement rights. These are property issues. The judge is going to talk to you about the law on that. Easements generally, layman's terms, the right to use somebody else's property. The facts surrounding the grant of these easements, they're not in dispute. Easements were created by prior property owners in 1996. You're going to see the easement agreement. It's going to say it's a perpetual easement over and across what is now the Anderson property, two separate areas, easement 1, easement 2. You're going to hear, you heard from Mr. Edwards. The Andersons bought their property from Ann Nykirk. Ann Nykirk's a real estate agent in Atlanta. She sold the property to the Andersons. Their deed says your property is subject to the same easement agreement. Certainly, if this easement agreement had been extinguished or easement 2 no longer was in existence, certainly Ann Nykirk, a real estate agent, a prominent one in the Atlanta area, wouldn't have put into the deed that this property is subject to these 2 easements. The closing attorneys, same closing firm for both sides. Andersons buy their property in September of 2018. A year and a half later, the Davids buy their property, March 27, 2020. Same closing firm. Their deed also mentions your property is subject to the same easement agreements, giving you rights to the use of 2 easements on what is the Anderson property. You're here that not only did they have the same closing firm, but the understanding that was provided to the Davids when they asked about the easements was, you have the sole and exclusive use.
Object, she's getting to legal arguments. She's giving legal advice as to what closing attorneys may have said, that's improper.
I'm not your under, this was one of the issues we talked about before as to what the understanding of the clients were when they purchased the property.
Okay, just make sure it's not coming from the mouth of the closing attorney.
Sure. So the understanding of the Davids when they purchased sole and exclusive use of these easement areas. What does the easement agreement state? You're going to see it. It's tiny, so hopefully we'll be able to also show you it blown up in size. 2 easement area. This easement agreement is recorded. That means it's in the Fulton County property records. If you look it up, you're going to see hey, here's reference to this easement agreement, and then you can go find the recorded and filed easement agreement. Easement 1, it consists of a brick parking pad. It's part of the natural ride parking turnaround area for the Dobbies. It's built in the same characteristic and style as their home. They use it to park. Okay, it's surrounded by a brick wall. It specifically says in the agreement, and again, you can read it, the Andersons are not to interfere with the use of that by the Dobbies. Easement 2, language in the easement agreement. Sole, and it says, for any legal purpose, you can use this area for any legal purpose whatsoever in the easement agreement. Both sides have, both sides got, both sides knew about. Those are the rules under which we're operating. Those are the rules under which these parties come to this property. Despite those explicit rules in the agreement, and both, I should say, both easements also say, easement 2 in the agreement says the same thing. Andersons, you have no right to interfere with the Dobbies' use of easement 2. And despite that, that is what has continued to happen throughout this case. Since the day the Dobbies purchased their property. I want to take a moment because what you heard Mr. Edwards say is they want to distract you really from all their conduct and activity. They want to say, hey, look, this was extinguished. Don't be fooled. The judge will give you the law, but don't be fooled on what they're saying. Again, they bought this property subject to this easement agreement. It was sold to them from a real estate agent prominent in this area with the full understanding that that easement agreement was there. There is no evidence that they can offer that anybody has modified this agreement or anybody has rescinded it. Has not happened. Evidence will also show that my clients, before they purchased their property, they walked through easement 2. I know, crazy, right? That wooded area that has ivy in it. They hiked right through it. Went through the woods up to the back of their property. You'll hear other people have done it too. There is no extinguishment here. Even if they did use it to throw refuse in, it doesn't defeat the purpose of it. It says you can use it for any legal purpose. You will hear from the Dobbies that for them, it was one of the selling points. One, we've all heard Atlanta is the city in the forest, right? They really liked the fact that it was wooded. It gave their backyard this sense of real privacy and shielding. They also liked another feature of it. The fact that you could get to West Andrews. Haversham is a busy road. They have young kids. This concept that you can park on West Andrews, you can go up through the woods and you can get to the house. You've got options. They like that. That was attractive to them in the purchase. And so don't be fooled about this concept, oh, it was extinguished and so we had every right. They bought it knowing full well there was an easement agreement on it. Also want you to pay attention to the fact that, hear me say, Andersons bought in September 2018. The Dobbies purchased their property a year and a half later. The Andersons made no use of easement 2 until after the Dobbies moved in. Let's talk about a few things that came up. The Dobbies were renovating. They had workers. They had workers that parked on West Andrews. West Andrews is a public street. You can park on West Andrews. They had workers who knew you could go up through the woods to our house. We all understand how construction can go. It's annoying, sure. And it's annoying when a neighbor does it and we live through it and we try to work through it. And the thing to do is knock on the door. right? You got a problem, knock on the door. So I didn't hear about these workers. The storyline that's been passed for you is not the same. The trash. Yeah, they threw trash in their dumpster. Anybody that's done a construction project knows you pay by what goes in there and you pay for the new dumpsters. Was the trash really a big deal? No. They would have liked for the Andersons to have asked, hey, are you cool with us throwing, these are kind of big things, can we throw them in your dumpster? You got it next door? Yeah, sure, probably would have been fine. What happened, Mr. David went next door, knocked on the door to try to, he thought, this would be a good chance to maybe go and introduce him, say, hey, I'm your trash in my dumpster, I'm your neighbor type of thing. You'll hear from Mr. David, that did not go well. That did not go well. His neighbor did not want to talk about that. Shortly after the Davids moved in, shortly after these incidents, these supposed incidents that the Andersons talk about with the workers, the Andersons decide they're going to clear easement to a portion of it. They don't contact the Davids. They don't notify the Davids. They just go in and clear it. The Davids are upset by that. I mean, they purchased it. One of the features that they liked was this wooded area. No notice, no contact. They didn't just do that. They put up a fence. You can put up a fence. You can fence your property line, right? They didn't just put up a fence on their property line. The intent was to run it all the way down, not just their property line, but the easement too, so that it would block via a fence any access the Davids would have to easement too. You heard Mr. Edwards say this all started in February of 2021 when there was the yelling, Mr. Anderson yelling at Mrs. David. But I'm going to show you their landscape plan from August of 2020. The Andersons' landscape plan for their property shows them using all of easement 2. It shows them extending a fence down all of their property to block easement 2. It shows them putting a fence along the easement area and West Andrews, so that you're really fencing off this whole easement area that they knew and the Davids know the Davids have the right to use. So this didn't start in 2021 with the yelling incident. This was an intentional design and pattern by the Andersons. And they may have been angry. They may have been angry that there were workers. They may have been angry that there was construction. But this type of action is not justified for such anger.
I'm sorry, justified for, I'm sorry.
Such anger.
Thank you.
The Andersons, there was some mention of sod. Davids have no problem with the Andersons sodding their property. Again, look at the landscape plan we're going to show you. 2020. It clearly shows that the intent was to sod easement 2 as well. They admit they sodded the area. They admit they put in an irrigation system. Oh, it just so happened that one of the irrigation head sprinklers is on the easement. That's what they're going to tell you. It just so happened, but it's a plan. They have a landscape plan. It says we're going to do this. They put lighting in trees in the easement area. This all happens. This all happens before there's any legal action. This all happens, and then Mr. Anderson yells, "You fat bitch, you're gonna die," at Mrs. David. But again, he said, Mr. Edwards says he regrets it. He's sorry. You did not hear anyone knocking on a door. You did not hear any apology. But it's not the first time Mr. Anderson has made remarks. They want to try to claim, hey, look, I lost my cool. It happens. It's not the first time. It continued. After this lawsuit was filed and you saw the videos, you will see that the Andersons have taken it upon themselves to film the Davids when they're out on the easement area. You're going to see Mr. Anderson filming the David's teenage son. You're going to hear from the son in that video. I don't like it. I'm 13. Please don't do that. It's weird. Who does that? Who films a kid out on an easement? He's got a little cross strike and a lacrosse ball. You're going to see him film Mr. David. You're going to hear from Mrs. David. And again, keep in mind, her husband travels for work. So he is gone Monday to Friday most of the time. You're going to hear from Mrs. David that on 2 occasions, Mr. Anderson yelled racial slurs at the Davids in front of their son. He called them Algerian niggers. Who says that? Who says that? This is not a man that yelled at a lady one time, calling her a fat bitch. This is a repeated conduct and disclosure. Does not like his neighbors, and he wants them to understand that they are not welcome near his property. He does not want them to use easement 2. You will also hear that at one point, Mr. Anderson, he owns a shotgun. You will hear that he took that out of his car, supposedly carried it to his garage. You will hear that that was done in front of one of the David's children. Again, these folks are already on edge. Their new neighbors are not at all what they had envisioned when they purchased that home to be. This is not the neighborly situation they were hoping to walk into. And what we will show to you through this pattern of activity and conduct that has happened is that this is intentional. It is designed to prevent them from accessing and using these easement areas. It is designed to interfere with the rights that they acquired under that easement agreement. Says you can use easement 2 for any legal purpose. That can be for woods, that can be for walking, that could be for playing ball. Regardless of how they want to characterize the area, the Davids have the right to use it for any legal purpose. And there is a pattern to what is going on here with the conduct of the Andersons. Make no mistake about it. Nobody yells those kind of things at their neighbors. Nobody behaves in that kind of way. What we hope is for that knock on the door. That is not what Mr. Anderson has done here. And then they sued us. They sued us. You heard Mr. Edwards. Yeah, we got your letter. We decided to sue you, right? You heard him. We don't want to be the defendant. We want to be the plaintiff. And so we're going to sue you. So here we are with all of you all, hoping that you can help us put an end to this living nightmare. yes, we hired someone to assess value of a cleared area. Mr. Shostak. You'll hear that he did what anybody would do when at the time you don't have information about what was actually cleared. Okay? If you have information, you use the information. If you don't have information, is there stuff on the ground? If you don't have stuff on the ground, is there another way to do it? And so he'll tell you why he did the appraisal analysis he did, and why he came up with the analysis he did. The reality here is that the focus is on this blatant and constant barrage against the Davids that has interfered with any right to use easement 2. We are blocking you from this. We want to end this nightmare. We need you all to help us. You heard Mr. Anderson, Mr. Edwards talk about some property stakes, survey markers. It's pretty common when you have property and you want to know where the boundaries are. You have somebody flag it, stake it, and put up markers. What you'll hear is that Mr. Anderson took those down. Again, we've got young kids. So the fact that somebody went out there and take back up, that is to be certain, right? That is to be clear. You are on the easement and you are not on the Anderson property, right? There's nothing untoward about that. The purpose of those stakes and those markers is to make sure everybody knows this is easement, this is Anderson property. Don't go on Anderson property, you can be on easement 2. But apparently, that's unsightly. And so the Andersons pull it down multiple times and the parties attempt to put it back so that everybody can be real clear. I will close with this. Again, my clients didn't bring this lawsuit. The Anderson product, the conduct, the pattern of conduct, the reprehensible yelling, name calling, what have you. It's not neighborly. It's not kind. It's not a way any neighbor should act, regardless of whether you lose your cool. The Davids need your assistance in making this stop. And after you've heard all the evidence in this case, and the judge explains the law to you, we are going to be asking you to return a verdict in favor of the Davids. Appreciate your time and attention this morning and throughout this case, and for your service. Thank you.
Thank you, Ms. Sturm. Ladies and gentlemen, before I ask Mr. Edwards to call the first witness on behalf of the Andersons, I'm going to give you the morning break. We've been focused on the openings, and I want to make sure you're refreshed. We'll go, our lunch break is going to be just a little bit before 12:30. It will be an hour. Lunch will always be at least an hour. I have a meeting back in my chambers at 12:30, so we're going to need the break a little before 12:30. Take that hour lunch and then
May we approach?
She wants to do her brief opening.
Oh, you don't even need to approach.
Okay.
There's a funny third. It's not funny as in funny, haha. There's a necessary third piece to the openings because Ms. Medwick has a specific role on the team with the Andersons. She is handling the defense of the counterclaims. I mentioned to you all that even though the Andersons are listed as plaintiffs, it's Andersons versus Davids. I didn't mean to leave you out of this. The Davids brought counterclaims. They are the plaintiffs, if you will. They have the burden of proof, preponderance of the evidence as to the counterclaims. And the way that the Andersons team has divided this up is Mr. Edwards is focused on, if you will, prosecuting, proving up the Andersons' claims. And Ms. Medwick is much more defending against the Davids' counterclaims. And so it is appropriate for her to speak as well. Don't apologize. I forgot the way we're going to flow. So you may, from time, we may every once in a while have a witness where both Mr. Edwards and Ms. Medwick ask questions of that witness, even though, wait a minute, the lawyers are all right there. It will only be one lawyer from the David's side who gives an opening or handles a witness, but the Andersons have this kind of dual role because the counterclaims were brought. And so I didn't mean to shortchange you at all. You'll still get your morning break, but we are going to hear from Ms. Medwick. She said it's super brief. Let's hold her to that.
Yes.
Her opening statement about the David's counterclaims. Ms. Medwick, if you would, please.
Thank you. I'm sorry to interrupt you, Your Honor.
No.
Good morning, and I am going to be very brief. What I cannot impress upon enough is what you're going to be asked to decide in this case concerns easement two. You're not going to be asked to decide if these neighbors should like each other, if they should like each other. You know, you're not going to be asked to decide that. You're not going to be asked to help them like each other. That's not what this case is about. And when it comes to the counterclaims that the Davids brought, it's about easement two. And whether or not anything that the Andersons did interfered with their reasonable use of it. So I want you to look out for evidence that talks about what was easement two like? What was easement two like when the Andersons bought it? You're gonna hear evidence. Weeds, poison ivy. If you don't know what railroad ties are, they're wood. So I did have to look that up at one point in time, so I'll admit that. And that it was rotten, thrown back there. Trash, plastic bottles, venomous snakes. You'll hear evidence that it was like that for a long time. And so that's why they cleaned it up. Did cleaning that up interfere with the David's use? You can decide for yourself about that. Pay attention to evidence about who didn't use easement two. When people did start using easement two, and by people, I do mean the Davids, when they started using easement two, when did they start using it? How did they start using it? How often did they start using it? And clearly there's one very uncomfortable interaction that has been admitted by the Andersons that was addressed to you. Other interactions are disputed as to if they ever took place, what if anything was ever said. So that'll be something for you to decide. But look at the timeline, look at the evidence. If there was continued use after uncomfortable conversations, decide for yourself. Was that an interference? It didn't stop somebody from using it. Did it interfere? So look out for evidence about that, because it's not about I didn't like something, I don't like you. It's about interference. So when it comes to the counterclaim, that's really what it's about. It's about interference. It's not about liking, disliking somebody. Certainly everybody's entitled to their feelings, but we need to stay focused on what this trial is actually about, what the evidence really says, and that'll help you make your decision. And one of the most important things that you have with you as you're listening to the evidence, as you're making your decisions, is your common sense. You answered a lot of questions yesterday. You're here. Thank you. You all have common sense. It's a really wonderful guide. So let it help you determine everything, determine the evidence you believe, apply the law when Judge McBurney gives it to you. And, you know, this decision is going to be your collective decision. We really do appreciate your time today. So I know you want that morning break. So I'm going to stop talking. Thank you so much.
Thank you, Ms. Medwick, and I apologize again for
I'm
making any
sorry.
decision that could be deemed as not acknowledging your right to address the group as well. I appreciate it.
Thank you.
So now we are going to take our morning break. This is your first break since the trial has started. You haven't heard any evidence yet, so there's really not a whole lot to talk about back there about the case, but you shouldn't do that anyway. Don't talk about the case. No outside research. If you didn't know what a railroad tie is now, Ms. Medwick has told you what she thinks one is. Still not evidence, but don't research anything. Enjoy as best you can the space back there. If you are low on any supplies back there, let us know and we will do our best to restock.
Very nice. And what you probably call-
May I see it? Welcome aboard.
You guys don't listen to what Deputy Gordon says. Repeat what you said, Deputy Gordon.
May I see it?
There you go. Logan is the only one who listens. Judge, sir.
As I recall from yesterday, you told defense counsel that they should approach before we raise this issue of the Algerian N-word, the verbal harassment. Ms. Sturm obviously did not do that. I just want to let everybody know, in my opinion, and you can correct me if I'm wrong, obviously.
Okay.
She's opened the door to the timing of when this claim was first raised. I had the very first email from Ms. Sturm where this issue was raised, which was November 9th, 2023, which is 2 days after the Supreme Court denied cert. So I intend to go into that with Mr. Anderson.
Okay, so two things. One, I don't recall saying that we needed to discuss again anything about any defense evidence that one of your clients said something racially insensitive. We talked about it, and my ruling was if it's coming in not as hearsay, obviously it's a statement alleged to have been made by Mr. Anderson. That part's not hearsay, but it's not Mr. David saying, my son told me that Mr. Anderson said that, then it can come in if that's where the defense wants to go. So I don't believe that Ms. Sturm crossed a line that I drew, but I understand what you want to do. And I guess you're gonna, where you'll need to be a little careful is getting into lawyer communications and what the significance of the Supreme Court's ruling was.
Just something to the effect of when's the first time you heard it? Does this refresh your recollection?
Yep.
Yes. Is there anything significant that happened in this case around that time? Yes, the Supreme Court ruled in our favor.
Okay. I mean, as long as I don't have an issue with that. I'll hear from defense counsel in just a moment, but I appreciate you managing it that way as opposed to diving into, well, they ruled in your favor on what? What did this? Actually, the Supreme Court just said we deny cert.
Well, that's,
That would then, but there's nothing wrong with you characterizing it that way. And that kind of shorthand is helpful because what I want to avoid is the lawyers diving into, well, here's what the Court of Appeals said or didn't say. And that's really not a jury matter. But the significance of that to what people, or the connection of the procedural timeline with what's going on substantively, I think is fair game for you to explore.
thank you.
Ms. Sturm, any issue if Mr. Edwards handles it the way more or less he described?
If it gets handled that way, that's fine. My big concern again is the kind of cherry picking of council communications. And I guess we'll just have to pay close attention.
Sure, and I don't know that there's an objection to Mr. Edwards picking Exhibit X, because then you'd be able to say, look at Exhibit Y, Z, A, B, and C. If you think that that paints a more complete picture in terms of refreshing recollection. I didn't hear Mr. Edwards say, and I'm putting any of these up. These are all, let me refresh your recollection, or I'd like you to refer to witnesses can look at things. If he's going to want to tender it, that's a different discussion. And I didn't hear him say he was going to tender it.
Correct.
That we would need to be much more careful about. Okay.
And that's fine. I guess my concern a little bit is around this concept that, you know, there's some kind of settlement discussion happening and they're claiming that that's the first time they heard it. But I will just pay close attention to what's going on.
Okay. Got it.
And Judge, by all means, if she has another email, settlement discussion or otherwise, before November 9th, where she used that, accused Mr. Anderson of using that language, by all means, offer it. I mean, actually offer it. I'm glad to have the jury see it
Okay.
because it doesn't exist.
Okay. All right. Let's bring the juror. Was there anything, Ms. Sturm, from the defense side? Okay. Anything from the counterclaim defense side?
No, Your Honor.
No. Okay. Let's bring the jurors in. We're ready for the Anderson's first witness.
We call Claire Anderson.
Ms. Anderson, come on up, please.
What you said, can you raise your right hand? And you swear affirm that the testimony will be the truth, the whole truth, and the truth of the God. Fill in your seat.
All right.
Can you state and spell your name for the record?
Yep, but first, let's make sure that the microphone is near you and that it's on. You bend it right around. I don't see a little light on it. Does it have a light? It's
Says
working.
unmute.
Great. Okay. So if you would state your name and spell your name for the record, please.
Okay, Claire Anderson, CLAIREANDERSON.
Edwards.
All right, Claire, I know we kind of talked about the order of how I was going to do this, but I want to change it based on Ms. Sturm's opening.
Okay.
I'm going to talk about the elephant in the room, so to speak. The Algerian N-word. Is that a word or phrase that your husband would ever use?
Absolutely not.
Why not? Well, let me ask you this. Is he a racist?
Absolutely not.
Everybody denies being a racist. What can you point to support that?
Well, I was thinking about that when I heard that. Our daughter is a teacher, and this is an example. Our daughter is a teacher, and she taught at KIP Academy. It's by the airport, and it's a charter school, but very, very poor students are there. And she came home soon after she had started and was talking about a family. They had 11 children, 2 she had taught. And
Objection, Your Honor. Are we getting into hearsay on what the daughter?
Right, this is getting a little far afield.
It's leading to what she and her husband did. It explains their conduct and rebuts this totally.
Okay, you don't comment, you.
And
You can comment.
it rebuts this
Allegation.
allegation.
Okay. Okay.
and she was real worried because the mother was in jail and she came home and was real upset about it. And Tracy, we were just talking about what we could do. Well, we took these children in. Tracy, it was his idea, bring them home, feed them, give them a good place, to sleep, take them back to school. And just to prove our relationship with them, my daughter, the teacher, just got married. They were in the wedding. It was Tracy's idea to take care of them, and, it's something that none of us will forget. So that kind of shows that he is not a racist at all.
Thank you. Now, let's kind of circle back to where I originally planned
Okay.
to start. Tell us a little bit about yourself, just a minute. Where you're from, what do you do?
I'm from here. I'm from Atlanta, have 3 kids, all have graduated from college. And since then, I've really just spent my time, with them and painting, taking classes, and really selling my art, which I love. So it's a good distraction from not having any children at home.
And when did you and Tracy get married?
Right, 97, God, 97.
Okay. And y'all live where?
Andrews, West Andrews.
When's the first time y'all looked at buying the property that you currently live in?
Right when we were married, it was for sale, and we rode by and we loved it. We looked at it, and then we just decided we were going to rent right when we first got married. So we didn't buy anything. Then when we were ready to buy, I saw that it was on the market again, and we just were excited and remembered how much we liked it.
You toured the house on both occasions in
Yes.
97 and 18?
Yes.
Did you ever look at easement 2 on either occasion?
No.
Was it a big deal to you one way or the other?
No.
Did it appear to you, based on what you actually saw, that it had been used by the next door neighbors for any period of time?
No.
Okay. So you bought the house in 18. The David's bought in March of 20, right? Do you recall any, hey, we're your new neighbors, anything like that?
No.
What happened after well, let's strike that. In the year and a half between when y'all bought and the Davids bought, did y'all do anything to easement 2?
No.
No? They bought their house. What happened next?
Well, you know, when, like we've talked about, when you buy a new house, you make improvements. So we started with the yard. We had noticed that area, easement 2, was just a mess. I mean, all I remember thinking is there was just a huge pile, and it had debris and leaves, and, you know, so Tracy said that he wanted to just clean it out, just make it look nicer. But that's all we did, was just clean it out. Got rid of the railroad ties, got rid of the bottles, I remember there were plastic water bottles. So just, that was our discussion. For safety's sake, the light, we did put lighting in over that easement, but we also put it on the other end of our property. So we just did all that at once.
Landscape lighting, is that what it is?
Yes, landscape lighting.
Did y'all put David's property under surveillance?
No.
After the Davids bought the property, what was your first interaction with either I keep saying Davids, Davids? What was your first interaction either with them or people coming and going to their property?
I just remember when they were moving in, and there would be all the cars parked in front of our house, and people would be just walking in our yard, cutting through, but not down by the easement, just up on our grass, by our garage.
On both sides of the garage or the far side?
Far side.
The far side of the garage? Mm-hmm. But the east.
Just a yes or no.
Oh, okay, okay,
Yeah, thank you. I should have told you.
okay.
Saw them coming and going on the far side of the garage, but the easement's on the far side of the garage, right?
Correct.
Did they go all the way down to the easement area and go way down through the easement and then up to David's backyard, or did they cross over your yard?
They crossed over our yard. They did not go by the easement at all.
Do you remember what the street frontage of the easement looked like at that time?
Just overgrown?
Was there any path where workers could get in and out?
No.
So with your own 2 eyes, you saw people using your own property?
Yes.
And did you personally ever attempt to complain to the Davids about that?
No.
Okay. Did the Davids ever come and knock on your door and say, hey, we're having construction. If it's a problem, let us know?
No.
There's an incident with the trash. Do you know anything about that on your personal knowledge?
Yes.
Tell us what you know.
That we could not get to our garbage
Why not?
because of the cars
Why? Because-
blocking our garbage cans. And personally, I just remember one piece of trash that we had, and my son-in-law at the time was at our house, and he's 6'9", and he could reach over. Like normally, I couldn't have reached over into the trash bin. And we asked him to put a table in the David's trash bin.
Okay. So it took somebody 6'9" to do it. It's not something
Yes.
that even Tracy or I could do.
Right.
Okay. And did you ever have any discussions with either of the Davids about putting trash in their dumpster?
No.
Do you know where the dumpster was at that time? And by that, I mean, was it on easement 1 in the parking pad, or was it somewhere else, or do you know?
I think it was on easement 1, if not further down the driveway, but I can't swear to it.
Okay. Did you ever personally have any interactions with either Mr. or Mrs. DeVede before this lawsuit was filed?
Only Mr.
Tell us about that.
He came to our house one night and he knocked on the door and asked for Tracy. Tracy was out of town and he said, okay. So he kind of turned and then he said, oh, you can't have anybody live over your garage. And I just went, I kind of was dumbfounded. I just, okay. And I shut the door. I thought, I don't even know how to respond to that.
Did he try to give any explanation?
Nope,
Did he knock on the door again and say, you don't understand?
no.
Were y'all having work done above the garage at that time?
Not really. We just cleaned it out. It's studded for, plumbing and all that, but nothing has been done. We had just cleaned trash out of there. That's all.
Okay. And he didn't like you doing that?
I guess not. I
Uh,
understand.
Did you get a lawyer letter from somebody saying, hey, you don't have a right to do this? Knock it off? Okay. What about the trash? Did you get a lawyer letter about the trash saying, hey, knock this off?
No,
Stop. But you got a lawyer letter in February of 21, February 26th. It's written, I think it was delivered on the 27th. Does that sound about right?
I don't know what you're talking about.
Okay, I'll move on.
Okay.
Were you present at the house the morning where the incident occurred with the landscaping and the sod and Mrs. DeVede?
Yes.
Tell me what you saw first.
Okay. I didn't see anything going on when I was inside the house. I came down, was going to the garage to get in my car, and one of the workers came up to me and he looked horrified. His eyes were he did not speak English very well, but he said, we can't plant. She said, we can't plant. And I was like, what? Well, by that time, she was gone. Stacy was gone. But then I didn't do anything else. I was just going to call Tracy, and then he had talked to Jose,
Okay.
head of the landscapers, and he took care of it.
And then a little while later, there was this interaction between Tracy and Mrs. DeVede.
Yes.
Were you present for that?
No.
You didn't see it or hear it?
No.
Okay. Let me ask you this. You heard in my opening that she said that he had multiple marriages. How many wives has Tracy had?
One.
So he's had one successful marriage?
Yeah.
Okay. You mentioned earlier that he was out of town when Mr. DeVede came and knocked on the door. Tracy traveled a lot?
He used to. He used to travel a lot more than he does now.
So back in this 2021 timeframe, how much was he traveling?
Almost every week.
Okay. Other than this one incident, to your knowledge, has Tracy had any interactions with Mrs. DeVede?
Not that I know of.
And before the TPO was served by the sheriff, did anybody come knock on the door and say, hey, we need to talk about this? Can we just agree to keep our distance?
No, I wish.
Have you ever intentionally interfered with the David's rights to use easement 2, you personally?
No.
What do you want to come out of this lawsuit?
I just want what's fair. It's just a little embarrassing to me that we're all here doing this, to be honest. We don't want the easement in their driveway. Why would we want that? And easement 2 is on our property. Tracy's paid taxes. It's just silly to me that all this is going on. I guess that's pretty simplified, but If they want to walk through, we've offered to give them a path. What's wrong with that? You take your easement on number 1, easement 2, we'll make a path for you. Let us landscape it, make it look nice. You can see it from our house. I mean, I just don't understand.
Judge, I'm going to show this as witness. This has been marked as defendant's exhibit 14.
Okay, not in the binder?
That is that's my binder. I don't know if they've given you their binder.
No, right, so this is in your binder.
It is not in my binder.
Oh.
It's supposed to be in their binder.
Oh, okay.
That's defendant's exhibit 14. Claire, I'm going to share my iPad with you
Okay.
and show you what the defense has marked as defendant's exhibit 14.
Oh, yeah, okay.
Have you ever seen that document before?
I saw this on Saturday.
How'd you get it?
I guess you sent it to me you sent it to me.
And did you go back and check your social media, your cell phone and other things to see if you had received that and missed it?
Yes, and.
Could you find it?
I'm not real tech savvy. I even had my college, 1 year out of college, student daughter come down and help me look for it, and she couldn't find it.
So until Saturday, had you ever seen that document before?
No.
Thank Nothing further, Judge.
Do you have any questions?
No, Your Honor.
Okay. Ms. Stern?
Yes, thank you, Your Honor. Good morning, Mrs. Anderson.
Good morning.
We've met previously.
Yes.
Okay.
Good to see you again. Your husband, he's admitted he called Mrs. David a fat bitch, told her he hoped she was going to die.
Your question?
You heard that?
Yes,
And
but,
you're aware he said that?
but the end, what I've heard and what I understand from my husband is he hopes that, or about dying, that he was going to die from being so,
She was gonna die because she's so fat.
yes,
Okay. So those are the kinds of
Not-
things that your husband says.
no,
He said it to Mrs.
said that,
David.
yes.
Look, this is gonna go poorly if you talk over each other. So, Ms. Stern, one, make sure you're posing a question. It can be a statement, but it needs to end with a question mark. And then make sure Ms. Anderson has finished answering before you move forcefully or not to your next question. Because our court reporter can take down only one voice at a time. So when Ms. Anderson is done, then you can go on to your next question.
Thank you, Judge.
Sure.
Ms. Anderson, you have an Instagram account, don't you?
Yes,
Okay. You're a painter.
yes.
Okay. What's your Instagram handle?
Well, I have a regular Instagram, then I have my art Instagram. It is, and I haven't posted on it in probably over a year. So, I think it's I think it's CH Anderson Art. I can't, to be honest, I can't even remember for sure.
That's the art Instagram?
Yes.
Personal one.
Art. But I maybe even a year and a half, I haven't used it.
Okay. So it's possible that if somebody messaged you at that account, you didn't see it.
Lately, but I did look at that account on Saturday when I was looking for that text. My daughter and I did look at that account and my regular.
Okay. Have you changed your Instagram account?
No,
Never.
no.
Okay. Let's talk about the purchase of your home.
Okay,
You purchased your home with your husband, correct?
yes,
Okay. And did you go out and look at the property prior to purchasing the home?
yes,
Did you walk easement too?
no,
Did you know Ann Nykirk, correct?
yes,
And you knew her before you bought the home?
yes.
Did you talk with Ann Nykirk about easement two prior to purchasing the home?
No,
When you purchased the property with your husband, you purchased the property subject to an easement agreement, correct?
Objection calls for legal conclusion.
When you bought the house, had someone told you that there were easements on the property?
I'm sure that they did, but not me personally. I don't remember a conversation about an easement, to
When
be
did you
honest.
first learn that there were easements on your property?
Kind of when all this came up,
Okay.
to be honest, yeah.
You didn't talk with the closing attorneys about easements on the property?
I'm sure we did, and that's just something that I didn't really zero in, to be honest. I mean, so I can't say.
When the Davids moved in, did you go over and introduce yourself to the Davids?
No, and I should have. I admit that. That was not nice.
When your husband called Mrs. David a fat bitch, did you go over and talk to Mrs. David?
No,
In fact, you never talked to Mrs. David about those statements.
no,
You talked about, were you ever actually on easement two before the Davids purchased it?
you mean,
Before the Davids purchased their property?
physically walked in there? No,
So you had talked about, wait, I think you said was a huge pile
yes.
up here. Do you have any photographs of this huge pile you're talking about?
Mm-mm.
You see yes or?
No, I'm sorry. Thanks.
How we talk?
Okay,
You have 9 security cameras on your property, is that correct?
I don't know about the total number.
Are you aware of security cameras on your
Yes,
property?
yes.
Are you aware of?
It's part of our
So
alarm.
you need to wait till Ms. Sturm is done with her question. You are anticipating the answers just fine, but she needs to finish her question, either because she throws you a curveball and says opposite of, but you can't talk over each other. So let her finish and then you'll get all the time you need to answer.
Thank you, Judge. Are you aware of how many security cameras are on your garage area?
I think either 1 or 2.
But it surprised you to learn that there's 4.
But I don't know. It's all tied into the alarm system.
Do you have any photographs from your security cameras on this garage that show any of these workers you were talking about or Mrs. David interacting with any workers on your property?
No,
Did you ever contact the Davids about clearing easement 2?
no,
Did you ever contact the Davids about putting lighting up in easement 2?
no,
Did you ever contact the Davids about installing a sprinkler system that encroaches on easement 2?
no,
The trash in the dumpster, if I heard you correctly, you testified that you asked your son-in-law to put it in the dumpster.
yes.
Okay. And you don't recall where the dumpster was located?
The general area.
Is it possible it was sitting on the David's driveway close to their garage?
Well, yes, that's that area I was talking about in the driveway.
And isn't it true that the trash that went in the dumpster was prior to any workers coming to the David property?
I don't think so. I don't think that that's true, but I can't say for sure.
You don't know?
I don't know.
Okay. Mrs. Anderson, you never approached the Davids and asked them if they would sell or release their interest and easement to you and Mr. Anderson.
No,
Did you ask Mrs. Nykerk if she would approach the Davids about selling their interest in easement too?
no,
You didn't? And after purchasing your home, did you ever approach the prior owners of the David property, the Darbys? Did you approach the Darbys about their use of easement too?
no,
You didn't ask the Darbys if you could clear easement too?
no,
Okay, and you didn't ask the Darbys if it was okay to put lights in easement too?
no,
And you didn't ask the Darbys if you could put a sprinkler, install sod, or do any of that on easement too?
no,
Did you ask the Darbys if you could fence off or block easement too?
no. I've never seen the Darbys. I don't know them.
Did you ever make any effort to reach out or contact them as your neighbors?
No, but they didn't live there when we were there.
You don't believe they live there
No,
at all?
I've never saw anybody in that house before.
You didn't see anybody in the house?
No,
Did you ever, you talked about an interaction, strike that earlier statement. You talked about an interaction with Mr. David where he knocked on the door.
yes,
Is it possible that you're misremembering the communication with him?
absolutely not.
Okay. Is it possible that you interacted with him some other time?
About that? About the garage, you mean? Or
Just-
just any time?
Just about, did he ever knock on the door and say, hi, I'm your neighbor?
He knocked on the door and Tracy talked to him. I heard them talking and he mentioned the trash in the dumpster and Tracy said, well, we couldn't get to our trash cans because of the cars. And he was very nice. He apologized and said, I understand. I heard that. I wasn't standing up at the door. I was kind of behind Tracy when that conversation went on, but that wasn't directly with me. That was between Tracy and him.
So those are the two times that that you know of, that Mr.
Yes.
David has knocked at your door.
Yes.
Once your husband interacted with him, you were partially in earshot, and the other time, you were the only one home, and that was the, hey,
Correct.
no one up in your garage.
Yes,
During any of the time, we heard you talk about what you want or how you would like this to resolve. At any point in time, have you gone over neighbor to neighbor and talked to Mrs. David about what you want?
no,
At any point in time, have you gone over neighbor to neighbor and talked with Mr. David about what you want?
no,
Are you aware of comments? Well, easement one, you're familiar with easement one?
yes,
Okay, and you agree that's the parking area on the David property?
yes,
Okay. Are you aware of comments by your husband about uses of easement one?
no. But us using easement one? No,
Do you have any uses you would like to make of easement one?
no,
Are you aware of comments that, oh, well, we could go play basketball on
Your Honor, I
easement?
object. We need to approach.
Question, are you aware of comments over?
Oh, I'm sorry, Mr. Williams, I didn't mean you, thank you.
Oh, I'm sorry.
Real time, I'm directing Ms. Sturm to say, all right, I'm gonna do a little reset here, and here's my question. She
There
may
you go.
want to move on, she may want to stay where she was. Free to do mine.
Do you think an appropriate use for easement one would be for you and your family to play basketball on it?
No,
Okay. Do you think an appropriate use for easement one would be for you and your family to have a barbecue on it?
Your Honor, objection, we're talking about speculation as to what we can and cannot do. Obviously, we can do anything on that easement as long as it doesn't interfere with what the Davids are doing. So all these questions are great, but if this is the path we're going down, we'll be here for days.
Well, let's not be here for days. You can ask a couple more of those questions.
Thank you. Do you think an appropriate use for easement, for the use of easement one would be for a hockey game?
no,
With regard to easement two, and let me grab one thing. I'm gonna strike that for now, so I don't take up other people's time, but, Mrs. Anderson, in talking about what you would like to accomplish here, is it your belief, that the Davids cannot use easement two?
no.
Thank you. No further questions.
Any redirect?
Do you have anything? Yes, sir, just a few. I didn't ask you this. I showed pictures of nets and ribbons and stuff like that in my opening. Are those visible from your house?
Yes,
How often do you see those?
every day,
All day?
all day.
Did you see any use, did they have those nets and ribbons and everything up there before the fat bitch incident? I mean, Ms. Stern asks that question all the time.
No,
Did they have nets and ribbons and chairs and all
No.
that stuff before that?
no,
That was not until after the lawsuit was filed.
right,
Okay. Do you like seeing those every day?
no,
You want them gone?
yes,
She asked you questions about whether y'all asked the Davids before doing this, that, and the other. Obviously, the Davids came over and knocked on the door and said, hey, we're getting ready to put these nets up. Do you mind? Obviously, that happened, right?
that did not happen.
Really? Why not? But never mind, that'd be speculation. The Darbys lived there, so well, strike that. The Darbys owned that house for a year and a half before the Davids did while y'all lived there, right?
Yes,
Did you see any signs of life whatsoever from that house?
no,
Any lights on at night?
no,
How far is the driveway from your dining room?
Which driveway?
The driveway to the Davids' house? Approximately.
very good. It's really close.
From me to you?
Yes, about, yeah,
Okay. Got big windows in the dining room like
Yes.
for most people? Can you see people coming and going in that driveway?
yes,
In the year and a half that you lived there, did you ever see one single car come and go out of that driveway while the Darbys owned it?
no,
Did the Darbys ever complain to you guys about, we have exclusive rights to easement 2, you can't do anything, period?
no.
Ms. Anderson, a few more questions, and then if the lawyers have any follow-up, they will undoubtedly follow up. When you first started answering questions from Mr. Edwards, you shared with the jury an anecdote about your daughter as a teacher and some students that she taught. You mentioned that they were poor, economically disadvantaged. You didn't indicate white, black, Hispanic, Native American.
They were black. The whole school it's black.
Okay.
Yeah.
You referred to, or at least were asked about some landscape lighting that was
Okay.
installed on easement 2 or near easement 2.
It's way up in the trees down on easement 2.
Okay, is the tree in which the light is installed on easement 2 or on what we'll call Anderson property? If you know.
I don't know.
Okay,
I think it's on the easement, but I'm not sure. I
Okay.
think it's that far back.
And do you know if the lighting was installed up in that tree before the Davids moved in or after they moved in? And not knowing is okay. You don't look pained. Just
I know.
remember.
I don't know.
Okay. Do you know who, if anyone, is responsible for maintaining easement two? And who, I don't mean you versus your husband, but is it an Anderson responsibility to maintain easement two? Is it a David responsibility, or how do you think about that? If
We have maintained it up into this point, so I guess it's our responsibility.
at least you have assumed that it's your role to do that.
Yes.
Okay. All right. Do you have any follow-up based on those questions?
I don't have a follow-up, but I have one question that I forgot.
All right, Ms. Sturm, any objection? You get to follow up if you want to, a question Mr. Edwards forgot.
To both the questions and what Mr.
No. I wanted, Mr. Edwards remembered something he meant to ask Ms. Anderson. Really, we've closed that. I don't mind reopening it. I just want to give you the chance to object, saying, no, he actually did direct and redirect, so he may not ask her another question.
I believe that's the case. We've done direct and redirect.
Okay. One question?
Yes, sir.
Ask your one question.
In the couple of years that those nets have been in your yard, can you give the jury an approximate number of times that you have seen any children or other people out there actually playing with the nets?
A handful.
I was allowed one question.
Ms. Sturm, you can follow up on that question if you want, or any of the questions to which Ms. Anderson provided answers. And sure.
Ms. Anderson, just to be clear, you didn't do anything on easement two, no maintenance, nothing between the time you purchased the property in September of 2018 and the time the Davids moved in 2020.
I don't remember when we had it cleaned up. I don't know if they were living there or not, to be honest.
Isn't it true you don't actually know when anything occurred on easement two, or when people have been on easement two, or when equipment has been on easement two?
No, I do. Some things I know, but I don't know exact dates. I mean, I don't remember. I don't remember when we had it cleaned up. We just thought it was a nice idea to make it look better. And no idea that that would offend anyone.
But you didn't ask anyone about it.
No.
Okay, thank you.
The cleanup work that happened, I know you're not pinning a specific
Okay.
date on it. That's okay. But can you place cleanup time pre-Davids, post-Davids?
I guess it was after they had moved in, just because of all the issues that have come up.
Okay, thank you. I appreciate your testimony.
Okay.
You are free to step down.
Okay.
Mr. Edwards, call your next witness, please.
We're gonna call Daniel Venable. He is out in the lobby. He was subpoenaed.
Okay,
Want me to go to him?
you should, someone on your team should get him.
Okay.
Just to manage Mr. Venable's expectations, we're gonna go for about 8 minutes with the witness, then we have to break for lunch, because I gotta get to my office and turn on a Zoom to do my lunch meeting. So
Certainly.
he may get interrupted, and we'll do part one, pre-food for some people, and part two after we reconvene.
Sounds good. Thank you so much.
Sure. That may open things up for you. We'll see how it goes.
Can you state and spell your name for the record?
I'm sorry, is that for me?
Yes, sir.
Okay, my name is Daniel Venable.
Are you employed?
Yes,
All right. Who are you employed with? Spell, oh, I'm sorry. I thought he was asked to state his name. I apologize. I'm sorry.
sure, it's Daniel Venable, spelled Daniel. Last name is Venable.
Are you employed?
Yes,
Who are you employed with?
On Point Surveying and Mapping.
Okay.
And surveying and mapping. Yep.
And can you describe what your job is?
I'm a licensed land surveyor. We map out properties and commercial, residential, and do, plats and maps of those properties.
Okay, and are you, did you say you're registered?
I am.
Okay. Will you describe your job duties?
I work in both the field and the office. The field, I'm more of a, I guess like a project manager. I oversee the field crews, and then the office, I prepare proposals and review the plats and maps that our CAD technicians provide.
Okay. And how long have you worked there?
Since 2016, so 8 years. Yep.
Have you ever been out to 3350 West Andrews Drive in Atlanta, Georgia?
I have.
All right. Do you know who lives there?
I believe it's the Anderson residence.
Okay. And do you remember when you first went out to that property?
I do.
When was that?
I want to say, well, I guess I do. It's April 2020, I think was the date. I can look, it's on my plat, the field date, but
Okay. And
it's been a while. Yeah.
the plat on this one?
Don't
Or
put
the
anything on
survey
screen until
says.
it's been admitted.
Oh, okay. Yes. Well, let me, before it is that. Did you bring a copy of your survey
I
with
sure
you?
did.
Okay. And I believe it's a rather large survey, isn't it?
Yes.
Okay, we have a smaller copy. I'll show to the other side. Okay.
Your Honor, just a logistics, I'm assuming that it shouldn't be published yet to the jury until it's.
I said,
I apologize.
okay, nothing should go up on a screen until it's in evidence. I don't think there's anything that's gonna be admitted that can't also be published, so no one needs to ask about publishing. There are no autopsy photos or anything, so, once it's admitted, feel free to publish. If it's already been admitted, publish whenever you want, republish, but until it's admitted, jury shouldn't be looking at it.
All right. We'll take a look at that.
Sure.
Do you see the document I've handed you?
Yes,
Do you recognize what that is?
I do.
And what was the document I handed you?
It was the drawing or the plat that we provided the client after we performed the survey.
And is that what you brought? Is that a smaller copy of what you brought with you today?
That's correct. The size, the copy that I brought is a scaled copy, so it's the exact scale of the drawing, not reduced or anything, so.
All right, and I would move to tender that as plaintiff's two.
And you're tendering the reduced size version, or we're gonna be taking from Mr. Venable, the big one?
Is that a copy that's available to stay here?
Absolutely.
Okay, we'll take the large.
Okay,
When
so
is-
you make sure you label it, because that's something that'll go with the court reporter ultimately, but we'll go back with the jury, it goes back with the jury, but, any objection to admission of plaintiffs two?
Not necessarily, but we have not had an opportunity to compare the two.
Okay, assuming what you've got in the micro version is the same as the large version, plaintiffs two is admitted.
Okay, thank you. Okay, and looking at the copy of your survey, can you just describe like what this is?
So it's basically a boundary, topographic and tree survey, which the boundary shows the property lines and the dimensions around the property. The topography shows the elevations of the property, and then the trees, we identified all of the trees that were 6 inches in diameter and larger, and showed those on the map.
Okay, and that was for the was that for the entire property?
Correct.
Okay, and it looks like that the easements are included on this, is that correct?
That's correct.
Okay, so you also have the ability, or would you have the ability by looking at this to describe how many trees are on easement 2?
I would.
Okay, and so does the survey identify what date you went out there to go do it?
It does.
And what date is that?
I'll have to look if that's okay.
Sure, absolutely.
Okay, if you look at under the survey notes, is item number 5, it says last date of field work performed on for last date of field work. It says performed, go back to find it, on 04/02/2020.
Okay, thank you so much. And okay. Do you know, can you tell how many trees you identified on easement 2?
Sure.
For the less educated viewing public, are the easements the 2 gray areas?
That's correct, yes.
And easement 2 is the smaller or the larger of the gray areas?
Looks like it's the larger of the 2 to the far right of the page.
Okay.
Uh-huh. So it looks like there were 1, 2, 3, 4, 5 trees that were all the way on the property, and then there was one that looks like it's right on the property line. That would be tree number 12, it looks like.
Okay, and so if my math is right, that's about 6?
Correct.
Okay. And can you, does the survey include the dimensions of the trees?
It does. Well, it gives the size of the diameter of them.
And what, the diameter of what?
So that's going to be if you take what we call a tree measurement tape, and it's at your breast height. So you wrap the tape around the tree and it gives the dimension of that tree,
Okay.
whatever you read on the tape. So,
Okay, thank you. And can you describe the 6 trees that are on easement 2?
sure. Looks like it's going to be tree 14, 15, 16, 19, and 20. 14 is a 9. So it's a double tree. It's got 2, I guess, trunks coming up. It's a 9 and a 24-inch hardwood. Tree 15 is a 26-inch pine. Tree 16 is a 13 and 32-inch hardwood. Tree 19 is a 27-inch hardwood. And tree 20 is an evergreen, 6-inch evergreen screening. And then the one that was on the property line looks like tree 12, that was a 24-inch pine.
Okay. And do you remember when you were first contacted to do this survey?
Vaguely, it's been a while.
What's your recollection?
Basically, we either through phone calls or emails, most of the time we'll prepare a proposal for the client, they'll sign it, send it back, and that's basically our notice to proceed for the work.
Okay, and do you remember when you were first approached to do the survey?
I don't.
Okay.
I don't know why you're showing me.
Okay. Can you take a look at this for a minute?
Sure.
And let me know when you're done.
Okay.
Thank you so much. Did you have an opportunity to review that?
I did not.
This?
Oh, just now, yes,
Yes.
yes. I thought you meant before I got here. Uh,
No, I'm sorry. That's my
No.
fault. That was confusing.
No.
Okay. And did that refresh your memory on when y'all were first contacted about the survey?
Yes.
And when was that?
Well, I'll have to take another. Oh, I didn't look at the date. I was just reading the thing. I'm sorry.
Didn't ask you to memorize.
So looks like on March 3rd, 2020.
Thank you so much.
Sorry about that.
Okay, you are all good. Did you ever go back to the Anderson property at 5530 West Andrews?
We did.
Okay,
Right. Yes.
when'd you go back?
It was a couple of years later. I was contacted by a gentleman, Robert Jenkins, I believe is his name. And he was asking me to fill out an affidavit.
Okay, and did you actually go back to the property?
I did. I met him on the site.
Okay,
I met him out there on the site. Yes, sir.
and did you have an opportunity to look at easement 2 on that date?
We did. We went around the property and reviewed each of the trees that were in question.
Okay, and do you remember the date that you went back out there?
I don't remember the exact date.
Okay. I believe you said it was a couple years later?
Correct.
Okay. Do you recall when you went back out there a couple years later, were all the trees still there?
Yes.
They were?
Mhm.
Okay. Thank you so much. I have no further questions for you.
Right. This is where we're gonna break. Unfortunately, for you, Mr. Venable, you're gonna get lunch downtown.
Okay.
Eat lunch, but we need to break now. It is at multiple clocks here. I'm gonna go by the phone clock. It's 12:25. Let's try to be back by 1:30, jurors, 1:30. So don't walk more than 30 minutes in one direction because you want to be back in an hour. You're free to eat wherever. You don't have to eat at all. It's fine to eat as a group or subgroups. Just don't talk about the case. No outside research. Don't look up what a 24-inch hardwood means. If you've got questions about that, here's your man. You can ask him after lunch. So let's all try to be back by 1:30. Any logistical questions? Seeing none, we'll see you in about an hour.
All right, sir.
And council, I'll take up any issues you all may have when I get back from my meeting. So let's be back at 1:45. Good, thank you.
Oh, Mr. Venable,
We're supposed to come.
wait.
Oh, I'm sorry.
We don't want you to actually end up with the jury.
Okay, yeah.
Yeah,
Oh, God.
sheriff will send you back there.
I think that he can exit the courtroom now, right? Or Venable?
Yeah.
Okay, yeah. Did he say what time he wants us to be back?
Do I need to re-swear in?
You remain sworn.
Okay.
So be truthful.
I will.
Good afternoon, Mr. Venable.
Hello.
Judge, may I approach the witness?
Yes, so all the attorneys have a continuing authority to approach witnesses to hand things, not to stand right in front of them while you yell questions at them, but you can always go back and forth to drop things off.
I understand that's your.
Thank you. Thank you.
Okay,
I have a
good.
question for you, Ms. Stern. You had a chance, it sounds like, over the break to look at the big survey. Are you comfortable that the big survey can be plaintiff's exhibit 2, or you didn't look at it at that level of detail?
I actually didn't look at it all. Council just brought it to my attention that was here, but I will take a look at it shortly after. Okay. Good afternoon, Mr. Venable. My name is Casey Sturm, along with my colleague Jeff Schneider. We represent the Davids. I don't believe I've had the pleasure to meet you previously.
Right.
Okay.
Nice to meet you.
Nice to meet you as well. And I understand you're a land surveyor.
Correct.
Okay, and you're not an arborist.
No.
Okay. And I understand that you went out to the Anderson property.
Correct.
Okay. And you did a boundary topographic and tree survey for the Anderson residence
That's correct.
on April 6th,
Yes,
2020.
correct.
Okay. And if we pull up, I believe it was Defendant's Exhibit 2. That showing up. That's a copy of your survey.
Okay.
Is that correct?
Yes.
Okay. And I believe if you need to is it showing on your
On mine,
screen?
it's not
too?
showing on mine, but it says something about stay muted or unmute.
Oh, you should click stay muted.
Okay.
And then what's that one say?
Got it or leave meeting.
It says what?
Says got it or leave. It's talking about a third party or
Oh,
something.
just say got it.
Okay.
Don't leave the meeting.
Okay, now I can see
Excellent.
it. Perfect.
Okay. Now you can see it. Okay, good. Okay. And your land survey, your scope of work for this project, if I understood you correctly, it was to identify trees on the entire property.
Correct.
Okay. 6 inches DBH or greater.
That's correct.
Okay. And DBH again?
It's the diameter at your breast height. Yes.
So your survey would not pick up anything under 6 inches DBH, whether it was trees, shrubs, brush, what have you.
Correct.
And am I correct in understanding that the survey is based on a site visit on April 2nd, 2020?
That's correct. Yes,
Okay. And did you perform that site visit yourself?
I did.
Okay. On your survey, well, let me ask you this.
Uh-huh.
Did you walk the entire property during that survey?
I did. Mhm.
Okay. You walked to easement area 2?
Yes, because in the side of the easement areas, I also had to identify the trees, so I would have been all in that area as well.
Okay.
And locating the property corners and that and such. So,
Oh, okay. And you walked through the woods to do that?
yes, ma'am.
Okay. Easement 2 had not been cleared.
From my recollection, it was, it was trees and maybe some tall grass and stuff like, maybe a few briars, but, typical for wooded areas out in that area, so.
And you were able to walk through, no problem?
Yeah, I mean, I would have to, there were a couple areas I would have to, I carry a machete, so I have to chop. If there's vines or stuff in the way, then I have to clear it. But I don't recall having to do too much clearing out there.
Okay. Do you have any photographs from your site survey?
Typically are photos that we take are of the house and the driveway and stuff like improvements. I usually don't take photos of the actual, the tree areas.
So you don't take photos of any of the trees that you
Correct.
identify?
Correct.
And on your survey, if we look down in the lower left corner, there's some notes. Is that correct?
Yes.
In the very bottom note, what does that note say?
Yeah. Do you mind if I look at it on mine? I'm having a little trouble seeing it on the screen.
I'm fine with that. Just for your benefit, I understand I may be wrong that it blows up. Is that correct on his?
I can kind of see it. I mean, I'll have to
But you
look real
can,
close.
I don't think he can magnify, he can circle something. You would need to magnify. His screen simply shares what's on your screen, but then he can use his finger as a.
Oh, that's better. There you go. That's a lot better.
okay,
Okay.
thank you.
I'll just go ahead and read the note. Tree type label shown here on as requested by the client's design team and needs to be verified by the proper professional prior to planning or construction. On-point survey and assumes no liability as to the accuracy of these labels.
You said on point.
On-point survey, and yes. And so basically,
I need you to.
I'm sorry,
The
yep.
court reporter didn't catch all that. Start with.
Yes.
on-point
Okay,
surveying.
I'm sorry. Yeah, on-point surveying assumes no liability as to the accuracy of these labels.
Thank you. Let me hand you a photograph. Let me ask you if you recognize the image in that photograph.
I do not recall that image, but I've probably done 300 tree surveys since then, so they all kind of run together after a while.
Okay. Do you recognize any of that as easement area 2 on the Anderson property?
I don't recall that.
Okay.
So.
Thank you very much. Now, your survey, let me see if I can get it to zoom back out. Okay. It shows 2 easement areas, is that correct?
Yes,
And those easement areas are highlighted in gray.
that's correct.
Okay. And those easement areas, were they identified using the Anderson's deed and plat?
That is correct as well.
Okay. And if I look, I'm going to try to zoom in over here on easement area 4.
Okay.
Sorry.
You mean two?
I'm sorry, 2.
Yep.
Sorry.
No, it's okay.
I was thinking Blair Witch in my mind as I'm trying to enlarge this, and everybody's probably like, please stop. On easement area 4, am I on easement area 2? Sorry, Judge. Am I correct on the corners? Tell me what we see there.
So on 3 of those corners, you see, well, let's start on if you're looking at the screen, the top left, you see a little circle that has a leader to it that's identified as a 1/2-inch rebar found. So that was a found monument that we found on the site. And then if you go down the 60 feet to the right, you'll see a 1/4-inch rebar found. And then go down the 53.27 feet, you'll see a 1-inch rebar found. The other corner was not found, so it was actually, it's just a calculated point that's shown there.
Okay. And these found areas, you were able to find those in the field?
Yes, ma'am.
I don't have any further questions for you.
Does 1-inch rebar mean like that was a 1-inch diameter?
Diameter, yes, sir. Yes, sir.
Okay. Thank you, Ms. Stern. Any redirect or anything else from the Anderson side?
Very briefly, Your Honor. Mr. Venable, you were asked to read a note just a minute ago that said tree type labels.
Mhm.
Does that mean labeling what type of tree it is?
So a lot of surveyors will do it differently, the way they identify the tree. Some will actually identify, for instance, let's say it was a dogwood tree. They'll actually specify dogwood or maple or that. Because she asked me a question if we were arborists, we're not. So we put them in 2 classifications, basically hardwood or pine. I think we showed some evergreen screenings, which are like little holly bushes, but that's our way of like limiting our liability on the trees.
And that would be if there was this dispute as to what exact type
Right,
of
if
tree
it
that
was a
was.
maple or an oak or what, so, yeah.
Thank you so much. No more questions.
Anything else, Ms. Stern?
No.
Any questions from the jurors for Mr. Venable?